Hello and welcome to Case Readings. This is a series where, as the title suggests, we read cases. And we read them because they are interesting, and we also read them for their educational value. In fact, I've chosen most of the cases in this series from readings that are commonly assigned to law school students. In this particular series, we always follow a standard format. First, we look at the case citation, and then we think about some things we should have in mind as we read, and then we read the case. And that's it. So if you want to skip and go straight to the reading, check the timestamps down below because they will help you out with that. But we are not going to brief the case here. I do have some fine print that I have to cover before we start. First, these cases that we read in this series may not describe the current state of the law where you live or work, or where anybody lives or works for that matter. So don't rely on them for accurate statements of what the law says today. Always make sure to check your citators and look for good precedent in your jurisdiction. Also, I am not your lawyer. This is not a place to discuss personal legal issues that you might have. This is just a place to read cases for educational value. All right, and with that, let's get on to today's case. It's a little torts case by the name of Cordas v. Peerless, and if you are a fan of Shakespeare, you will like this one. And if you are not, you most likely will not. And actually, its name isn't Cordas v. Peerless. It's actually Cordas v. Peerless Transportation Company. We're going to see that the plaintiffs are suing a company and not a particular individual. And that might be something to think about, why they chose to sue the company. Oh, I said I wouldn't get into analysis. We're just going to read. All right, so the citation. We have the citation here in blue. So you can see the citation for this case, and it's kind of long, right? But it still follows the format that we hopefully are used to at this point, or if this is your first time looking at it, you'll get used to very quickly. NYS2D, that's the reporter. So a reporter is just a place where cases are written. And I'm avoiding the word published because that has some particular connotations, whether an opinion is an official published case by the court, and also particular reporters might be official reporters of the court. This NYS2D is not an official reporter of the court. It is the New York Supplement Second, and it is West New York Supplement. The volume number is that 27 at the very beginning, and 198 is the page number. And then we have the year, 1941, right? So you can see that we've got the year there, but what's the city court? Our reporter here does not tell us what court issued the opinion. We need to know that, and we put that information in the year parenthetical. Now, the next thing we need to do is think about what we want to have in mind as we are reading this opinion so we can get the most value out of it. What court wrote the opinion? We want to think about that. And what's the procedural history? Is this at the trial level? Is this at an appellate level? Is this something that has gone up and down the court system and is back at a trial level after being at an appellate level previously? Those are all things to consider. Who are the parties? What is the dispute about? Where did the events relating to the dispute happen? When did the events relating to the dispute happen? And why did they happen? And then we also want to think about the rules, right? What law might be at play to help us figure out what the answer to our legal question in this case is? Do those rules have elements? Are those rules balancing tests of some sort or some other kind of test? Maybe there's non-exclusive factors to consider. We need to then think about how the court applies those rules to the facts of this particular case. So watch out for the court's reasoning as we read. And with that, I think we're ready to go ahead and read this opinion. It was written by Justice Carlin. This case presents the ordinary man, that problem child of the law, in a most bizarre setting. As a lowly chauffeur in defendant's employ, he became, in a trice, the protagonist in a breath-baiting drama with a denouement almost tragic. It appears that a man, whose identity it would be indelicate to divulge, was feloniously relieved of his portable goods by two nondescript highwaymen in an alley near 26th Street and 3rd Avenue, Manhattan. They induced him to relinquish his possessions by a strong argument ad hominem, couched in the convincing cant of the criminal and pressed at the point of a most persuasive pistol. Laden with their loot, but not thereby impeded, they took an abrupt departure, and he, shuffling off the coil of that discretion which enmeshed him in the alley, quickly gave chase through 26th Street towards 2nd Avenue, whither they were resorting with expedition swift as thought, for the most obvious reasons. Somewhere on that thoroughfare of escape, they indulged in the stratagem of separation, ostensibly to disconcert their pursuer and allay the ardor of his pursuit. He then centered on for capture the man with the pistol, who he saw board the defendant's taxicab, which quickly veered south toward 25th Street on 2nd Avenue, where he saw the chauffeur jump out while the cab, still in motion, continued toward 24th Street. After the chauffeur relieved himself of the cumbersome burden of his fare, the latter also is said to have similarly departed from the cab before it reached 24th Street. The chauffeur's story is substantially the same, except that he states that his uninvited guest boarded the cab at 25th Street while it was at a standstill waiting for a less colorful fare. That his passenger immediately advised him to stand not upon the order of his going, but to go at once, and added finality to his command by an appropriate gesture with a pistol addressed to his _ʀᴰʟᴞᴜ. The chauffeur in reluctant acquiescence proceeded about 15 feet, when his hair, like unto the quills of the fretful porcupine, was made to stand on end by the hue and cry of the man despoiled, accompanied by clamorous concourse of the law-abiding, which paced him as he ran. The concatenation of "Stop, thief!" to which the patter of persistent feet did maddeningly beat time, rang in his ears as the pursuing posse all the while gained on the receding cab with its quarry therein contained. The hold-up man, sensing his insecurity, suggested to the chauffeur that, in the event there was the slightest lapse in obedience to his curt command, that he, the chauffeur, would suffer the loss of his brains, a prospect as horrible to an humble chauffeur as it undoubtedly would be to one of the intelligentsia. The chauffeur, apprehensive of certain disillusion from either Scylla, the pursuers, or Charybdis, the pursued, quickly threw his car out of first speed in which he was proceeding, pulled on the emergency, jammed on his brakes, and, although he thinks the motor was still running, swung open the door to his left and jumped out of his car. He confesses that the only act that smacked of intelligence was that by which he jammed the brakes in order to throw off balance the hold-up man, who was half standing and half sitting, with his pistol menacingly poised. Thus abandoning his car and passenger, the chauffeur sped toward 26th Street and then turned to look. He saw the cab proceeding south toward 24th Street, where it mounted the sidewalk. The plaintiff mother and her 2 infant children were there injured by the cab, which, at the time, appeared to be also minus its passenger, who, it appears, was apprehended in the cellar of a local hospital, where he was pointed out to a police officer by a remnant of the posse hereinbefore mentioned. He did not appear at trial. The 3 aforesaid plaintiffs and the husband-father sue the defendant for damages predicating their respective causes of action upon the contention that the chauffeur was negligent in abandoning the cab under the aforesaid circumstances. Fortunately, the injuries sustained were comparatively slight. Negligence has been variously defined, but the common legal acceptation is the failure to exercise that care and caution which a reasonable and prudent person ordinarily would exercise under like conditions or circumstances. It has been most authoritatively held that negligence in the abstract, apart from things related, is surely not a tort, if indeed it is understandable at all. In Steinbrenner, it is said, the test of actionable negligence is what reasonably prudent men would have done under the same circumstances. Connell v. New York Central and Hudson River Railroad Company holds that actionable negligence must be predicated upon a breach of duty to the plaintiff. Negligence is not absolute or intrinsic, but is always relevant to some circumstances of time, place, or person. In slight paraphrase of the world's first bard, it may be truly observed that the expedition of the chauffeur's violent love of his own security outran the pauser, reason, when he was suddenly confronted with unusual emergency which took his reason prisoner. The learned attorney for the plaintiffs concedes that the chauffeur acted in emergency, but claims a right to recovery upon the following proposition taken verbatim from his brief. it is respectfully submitted that the value of the interests of the public at large to be immune from being injured by a dangerous instrumentality such as a car unattended while in motion is very superior to the right of a driver of a motor vehicle to abandon same while it is in motion, even acting under the belief that his life is in danger, and by abandoning same he will save his life. To hold thus under the facts adduced herein would be tantamount to a repeal by implication of the primal law of nature written in indelible characters upon the fleshy tablets of sentient creation by the almighty lawgiver, the supernal judge who sits on high. There are those who stem the turbulent current for bubble fame, or who bridge the yawning chasm with a leap for the leap's sake, or who outstare the sternest eyes that look out brave, the heart most daring on earth, pluck the young sucking cubs from the she-bear, yea, mock the lion when he roars for prey to win a fair lady. And these are the admiration of the generality of men. But they are made of sterner stuff than the ordinary man, upon whom the law places no duty of emulation. The law would indeed be fond if it imposed upon the ordinary man the obligation to so demean himself when suddenly confronted with a danger, not of his creation, disregarding the likelihood that such a contingency may darken the intellect and palsy the will of the common legion of the earth, the fraternity of ordinary men, whose acts or omissions under certain circumstances make the yardstick by which the law measures culpability or innocence, negligence or care. If a person is placed in a sudden peril from which death might ensue, the law does not impel another to the rescue of the person endangered, nor does it condemn him for his unmoral failure to rescue when he can. This is in recognition of the immutable law written in frail flesh. Returning to our chauffeur. If the philosophic Horatio and the martial companions of his watch were distilled almost to jelly with the act of fear, when they beheld, in the dead vast and middle of the night, the disembodied spirit of Hamlet's fathers stalk majestically by, with countenance more in sorrow than in anger, was not the chauffeur, though unacquainted with the example of these eminent men-at-arms, more amply justified in his fearsome reactions when he was more palpably confronted by a thing of flesh and blood, bearing in its hand the engine of destruction which depended for its lethal purpose upon the quiver of a hair? When Macbeth was cross-examined by Macduff as to any reason he could advance for his sudden dispatch of Duncan's grooms, he said in plausible answer, "Who can be wise, amazed, temperate and furious, loyal and neutral, in a moment? No man." Macbeth did not by a tricksy word thereby stand justified, as he criminally created the emergency from which he sought escape by indulgence in added felonies to divert suspicion to the innocent. However, his words may be wrested to the advantage of the defendant's chauffeur, whose acts cannot be legally construed as the proximate cause of plaintiff's injuries, however regrettable, unless nature's first law is arbitrarily disregarded. Plaintiff's attorney in his brief cites the cases of Grunfelder v. Brooklyn Heights Railroad Company and Savage v. Joseph H. Bowland Company as authorities for a contrary holding. Neither case is apposite in fact nor principle. In the classic case of Laidlaw v. Sage is found a statement of the law peculiarly apropos, that the duties and responsibilities of a person confronted with such a danger are different and unlike those which follow his actions in performing the ordinary duties of life under other conditions, is a well-established principle of law. The law presumes that an act or omission done or neglected under the influence of pressing danger was done or neglected involuntarily. It is there said that this rule seems to be founded upon the maxim that self-preservation is the first law of nature, and that where it is a question whether one of two men shall suffer, each is justified in doing the best he can for himself. Kalanka v. Erie Railroad Company says, The law in this state does not hold one in an emergency to the exercise of that mature judgment required of him under the circumstances where he has an opportunity for deliberate action. He is not required to exercise unerring judgment, which would be expected of him, were he not confronted with an emergency requiring prompt action. The circumstances provide the foil by which the act is brought into relief to determine whether it is or is not negligent. If, under normal circumstances, an act is done which might be considered negligent, it does not follow as a corollary that a similar act is negligent if performed by a person acting under an emergency, not of his own making, in which he suddenly is faced with a patent danger, with a moment left to adopt a means of extrication. The chauffeur, the ordinary man in this case, acted in a split second in a most harrowing experience. To call him negligent would be to brand him coward. The court does not do so, in spite of what those swaggering heroes whose valor plucks dead lions by the beard may bluster to the contrary. The court is loath to see the plaintiffs go without recovery, even though their damages were slight, but cannot hold the defendant liable upon the facts adduced at trial. Motions, upon which decision was reserved, to dismiss the complaint are granted, with exceptions to plaintiffs. Judgment for the defendant against the plaintiffs dismissing their complaint upon the merits. 10 days stay and 30 days to make the case. And you're done! You're done with reading the case! Now go brief it.